Thank you for this opportunity. It really is, it's a privilege to be with you. And I am glad to speak with you about this topic, which of course is very dear to our hearts. It's something that the Pontifical Commission has been discussing for many years. And in fact, I'll share with you that one of the first places actually that the term vulnerable persons was used at the Vatican was with our commission. It's part of the name of the commission, and we've been part of the development over time. So really that's our goal here, is to discuss, these are the goals for your conference, to clarify, to discuss the understanding of this term. What does this term mean as it is used in church law? And then, what are the situations in which this definition is being applied? How is it being interpreted? And then how should we look at the abuse of vulnerable people? So it's a legal discussion on purpose to clarify this concept, this idea. It is 2:00 in the afternoon. We note with compassion. Well, people from around the world with us by video, they're at different points, but we'll do our best. It's a technical discussion, I realize. I will do my best to help enliven the discussion, but it's very important, I think, that we seek this clarity, which is the purpose of your conference. What does it mean as it's stated? And then where do we go moving forward? How is it that the church wishes then to apply what it is that has been given to us relatively recently? You think of canon law.
I'm sorry, but no one can enter it online. If we just would wait a few minutes, because they will be unhappy that they miss it.
Oh.
Just they are going to say yeah, I see it already. 8 participants. That's not possible.
Yeah,
Okay.
that's right. That's why.
Something is wrong.
Excuse me, sorry to
just
interrupt.
I'm sorry to
Good. Well,
interrupt,
I will talk to us. Let me know.
Yeah.
I will talk to us.
Well, you could tell something else.
Because the goal really of what I'd like to do is lead to a discussion.
Well, he's gonna.
So
I asked you to wait a moment.
I'm going to present what I think to be, and I'll tell you why, what I think to be what it actually says, which is an important foundation. Listening, however, to the presentations that I've heard thus far and speaking with you at table, I think many of us already agree that what it says is a rather restricted meaning. However, how that is interpreted and then how it is applied and how we move forward will be the second part of what I'd like to do with you. So I'd like to tell you why I interpret it that way. And then you'll have a chance tomorrow, actually, with Archbishop Arrieta, who will discuss with you where this idea has been going, particularly in the development of the new Book 6 in the Code of Canon Law. He is the secretary for the now dicastery. Well, next week it will become it's a long-standing group that was the Pontifical Council. It will become a dicastery for the interpretation of legislative texts. They were responsible for writing the new Book 6. The new Book 6 does not use this term, vulnerable persons, but it does refer to it existing in other laws, which is an important piece that we will cover. Maybe I can get some things out of the way that we won't have time for then. You do understand, I hope, why we say vulnerable persons and not vulnerable adults generally. The idea is that this concept began in the context of the abuse of minors. So you speak of vulnerable adults when you're distinguishing them from minors. Minors are obviously vulnerable. But there are other places we use the term vulnerable, which includes minors. So they are vulnerable persons too. So there's no problem with it. It's the same idea, the vulnerable among us. Sometimes minors, when we speak about sexual abuse, are in a different category, and I'll explain why. Sometimes we speak of them together, we speak of vulnerable persons. There's really no, but that's why it can seem mystifying to many people. Some of these things are easily explained. But some of them are a little harder. So what we're going to try to do is we're going to try to clarify together. What is this? Where does it come from? Oh, we're zooming. We will do our best. What I hope to do at the end, what I'm going to do in the first part is I'm going to explain why I think this is what it says. And then I'm going to give you the representative response of one archdiocese when asked, does vulnerable persons include religious sisters and seminarians? I'll give you the response they gave, which I thought was pretty good. It was nuanced. But I do think it's an important foundation for us to agree, what does it say? Because people all over the world are asking, what does vulnerable persons mean in Vos Estis Lux Mundi? Believe me, I know that because of ad limina visits of bishops. You know what that is? Every bishop is supposed to come to Rome every 5 years. There are so many bishops now that it's difficult scheduling them all, and then we have COVID. But anyway, every bishop is supposed to visit the Holy Father. And when they come, they meet with us who are in charge of the different dicasteries. So I met with bishops from around the world for the past 10 years. And they all want to know, you know the question is coming, you can be prepared. What does vulnerable persons mean?
Are we okay now? Yes, okay, so sorry.
Okay, welcome back to everyone. Welcome to everyone who's now joining us online. We had some technical difficulties, but we think we're ready. So let's go. What we're going to do, now I can't use my clicker.
Yes, you can.
My clicker no longer works. In any case, what we're going to do, as we've been speaking about together, thank you. There we go. What we're going to do is pursue the goal of our conference. The conference is to clarify the meaning. And what I'd like to do when we're talking about definitions in any field, when we're talking about definitions in law, you need to be clear about certain parts of it, easily seen, the who, the what, the when, the where, the why, and the how are things that need to go into a definition. And in this case, it's important that we look very clearly at what the law does say in canon law. And then what I'm going to do is broaden the discussion to civil law. What do civil laws around the world, particularly here in Canada, since this is where we are, what does it say about vulnerable persons? Who is being defined? What is being defined? And importantly, why? What is the purpose behind all of this? We can differ a bit about technical aspects of definitions, but why has the Holy Father defined a crime, well, actually two, that involve vulnerable persons? One is sexual abuse, one has to do with pornography. And that, I think, will help us. We listen and respond. We are seeking to safeguard this group of people. Now we need to define who it is that they are. Under what, which you can no longer see, is a very important distinction which we will return to. The distinction is between sexual abuse and pornography, which is defined under the category of vulnerable persons. And then there are other crimes which enter into the question of who does this apply to. These other crimes have to do with abuse of authority. And then a phrase that people are commonly using called power differentials. So that is not, you see the distinction there. What is in the canon now and in Vos Estis have to do with that first line there. Then we're talking about other things which we're going to come back to. So this is just a preview. Really, before beginning, may I just say, these are very personal matters. We're going to be doing a legal discussion here for a little while, but these matters affect our brothers and sisters in ways that if you hadn't had the chance to spend time with them, the profound nature of sexual abuse and what it does to the human person, and particularly the betrayal that they experience, a betrayal of confidence and of trust, is, I don't have strong enough words. I've been doing this for 20 years. It's been my job in the Archdiocese of Boston since 2002, and then working with the commission, the congregation. And also we'll be talking about religious sisters, we'll be talking about seminarians. This has been part of my work for 20 years, listening to their stories, listening to what has happened. And the desire that the church has, the desire that all of us have to respond to these terrible crimes, these terrible offenses, is really the foundation of what it is that we're talking about. We will be talking a bit in legal, very technical terms, But one thing I would like to do is to broaden our discussion, because when you're looking at definitions, an important thing is to say how it is that this law will then be applied to these situations. So someone comes forward, you're responsible in your religious community, in your diocese, in the place where you work. Someone comes forward and says, someone did something to me. Someone who has responsibility or someone who is in a position of trust did something, and I want a response. So I'm going to ask that we look a little more deeply at the question of who and of what and of why, because there are things that we can learn from the places that have been developing this concept at greater length than we have in the church. The church's definition, as I think you know, came from civil law. It came immediately from the Vatican City law. And the Vatican City law, which came in March of 2019, was then put into church canon law in June of 2019. And that itself has roots in the development since the 1980s, really, of this concept in the jurisdictions in which we live, which touch us as citizens. So what vulnerable person means in the place we live is a very present discussion. These are crimes. And when crimes are committed, we have a responsibility to respond. So it's developing very much. And the development, I think, if you look at these terms, you'll begin to see how it is that people who are working with these ideas, people who are advising the Holy Father, people who are developing laws in different places, different church places, dioceses, and Episcopal conferences, how are they doing it? What are they looking at? In particular, we're not just looking when we say who at the victim. We're looking also at the person who is harmed, that person, and we're looking particularly at their relationship. Defining that will help us to answer the question, who are vulnerable persons? It will be much more helpful, as you'll see in a moment, to be able to look at what it is that characterizes that relationship. And these words that are in the second part there are words that are being used in common law jurisdictions. I think will help. It'll help to broaden the discussion a little bit. The idea of special disadvantage and undue influence are things that can help us to understand that what we're talking about here is what is termed in common law, the doctrine of equity, that there is a special responsibility to take care of certain people. We all know this with minors. How is that to be equated with these people we call vulnerable persons? Oh, sorry, it's not working again. Oh, there we go. Just one note. How we do this, which is also a very important part of interpreting and applying, that's another talk. Putting the structures in place to actually do these things, to have people trained and experienced and working in a context where they can do it is an entirely different discussion. And I'm very grateful to be here at the Canon Law School of St. Paul University because they are training these people to be doing these things. But that goes beyond our scope at the moment. So what we're going to look at doing, this first phrase here is very important. The question is, can we define vulnerable persons for every single situation and simply apply that definition? It would be much clearer. You'll see in a moment, we've done that with minors. It's very clear who a minor is. We apply it to every situation and we move forward. Can we do that with vulnerable persons? Obviously, the answer is going to be no. And the context is going to be key. That the action, the crime, the offense happened in a particular context. We have to interpret that context. So we have to look at things like the person's understanding and their consent and define the crime in terms of how that person is affected. We have to look at whether the person is able to protect themselves. These are definitions that are being used in civil law, obviously, and help us to understand how these are working. And then these two ideas of unconscionable conduct, which has been developed in the civil courts, and undue influence. One looks at the perpetrator, one looks at the victim. So I just want to give you an idea of where we're going. Hopefully that will help a technical discussion and that we can discuss these matters together. Where's all this come from? As you can see, these are the fonts. These are the sources for the use of the term vulnerable persons in the church to this point. Interesting, the Pontifical Commission, I'll tell you in a moment, as I mentioned, is one of the first places. But this was quickly picked up in what's called the Ratio Fundamentalis. That is the primary document for the formation of seminarians, issued by the Congregation for Clergy, and it used this term, vulnerable persons, in 2016. Then it was used in two documents that have been foundational for this conversation, Come una madre amorevole, which I think is still effective, by the way. What it did is provide a process for negligence cases. When a bishop or a religious superior is negligent in prosecuting or in investigating a crime of sexual abuse, there's a process. It was mostly redone in Vos Estis Lux Mundi, which also has a process for negligence. But Vos Estis also went forward and defined crimes, including sexual abuse of minors and vulnerable persons. And, too long to say, but forms of pornography. It extended the crimes of pornography, which of course are developing so quickly that it's already out of date. But the things that are going on, it brought those into church law as well. What I will then say is we need to be attentive as well to the new code, the new book 6 of the Code of Canon Law, which is effective last December, because it does not use the term vulnerable persons, but it refers quite specifically to the law that does define vulnerable persons. It says it, you'll see in a moment. And then in the new Sacramentorum Sanctitatis Tutela, that's the document that came out in 2001, was revised in 2010, very importantly for us in this context, and then has just recently been, and is just recently now revised. It also does not use the term, but it does, in 2010, it defined a group of people that is the root of what we're talking about. It said not only minors, but people who, you'll see in a moment, who lack the use of reason, I'm sorry, that's a technical canonical. They habitually have the imperfect use of reason, is the technical term in SST that has then come forward. As I said, this will be very technical, but that's where we're going. So let's start with foundations. Let's start with the historical development. Where does this come from? There are important distinctions that are needed. A lot of this will be in the written text. It's too much for us here at the moment. But there are distinctions that are necessary in order to understand where this is going. There's a big distinction between legislation and then how civil courts and ecclesiastical tribunals then apply the law, how they interpret the law. This is very important to us from common law jurisdictions. So the distinction between civil law, which is the law that developed in continental Europe, and common law, which developed in Great Britain and has extended, is very important. I realized as I was preparing for this conference right here in Ottawa, because on this side of the river, you follow common law. On that side of the river in Quebec, you follow the Roman law, the civil law. There are very few places in the world where the same government, the government of Canada, has to deal with both. In the United States, Louisiana is the only civil law jurisdiction. So if you live on the border of Louisiana, you've got the same problem. This idea of vulnerable persons has been developed in both. The key, however, is that civil continental Europe law more relies on what the legislature, what the law is. If you want to know what the law means, you go to the legislator. For us, that's the Holy Father. If you want to know what it means, you go to the Holy Father, he tells you what it means. In common law, we have a system in which the courts take the law and apply it, and they apply it to particular situations and come to an understanding of what it means in that situation. And then they write it up, they write up their decision. We have jurisprudence, we have precedent, we have something that has the force of law as it moves along, these decisions. Much bigger discussion than we have time for, but it's very important as we try to understand canon law and moving forward with applying these ideas. And then in canon law, of course, we have a distinction between universal and particular law. The Holy Father issues law for the universal church. What we'll be talking about today applies to everyone. A special word, this is a footnote, side note, a special word, a blessing to our brothers and sisters from the Eastern Catholic churches. A lot of what we're talking about here is in the Western Code and is not yet in the Eastern Code. But vos estis applies to both, and sacramentorum sanctitatis applies to both. Then, in your local church, bishops can issue law. So in Germany, for example, the Conference of Bishops has issued a law that has defined vulnerable persons. And that applies within Germany. You see why this gets technical, gets interesting, why there's a lot of work ahead of doctoral students here at the St. Paul University. What you have to do if you're going to try to wrestle with these things is to understand what these words mean. So let me just do a bit of history for you, because I think it helps as you understand how these things have developed. The term vulnerable person really comes from developments in civil law and common law that have tried to address situations in which adults have been harmed and seek relief from the courts. They come and say, this person did this to me, and I want you to do this in order to bring relief. We're going to talk about abuse, but the place where this developed makes this, I think, easier to understand. The first place that this really developed was for elderly persons, and I'm not going to define elderly. This is a personal matter. I am now eligible for Social Security in the United States of America, but you see the problem. Elderly people who were financially disadvantaged, who were taken advantage of because of their position financially. It's easy to understand. The elderly woman down the street who is all alone is really worried about her finances. Somebody comes in, sells her something that he says will take care of all of her difficulties. It turns out to be a fraud. She loses everything. Should our society respond in that situation? Should we do something? The answer has been a resounding yes. We call this abuse, financial abuse. The person comes, and after the process, the court says that that person acted unconscionably, that we all recognize that that should not be done, and that that person made their decision because they lacked the ability to judge. They lacked the intellectual capacity to understand what was going on, and then to consent. You can imagine both sides, and you can see how this develops. Person who sold it comes in and says, she signed it. I explained it, she signed it, we have a contract. If every single person who feels that they got bad financial advice can go to court and have that transaction set aside, we've got a problem. The court then has to say, however, in this circumstance, that person was not able to understand. You didn't do what it is that we understand you should do, and therefore, we're going to set aside that transaction. We're going to give her back her money. You see the idea, easy enough. How does this happen with abuse? It gets much sexual abuse. Obviously, it gets more difficult because we're dealing with personal relationships. But this is why it developed, particularly from that point of view of looking at disabled people. What the definition of vulnerable people certainly means is that there are people who are suffering under some kind of disability, and we have a responsibility to care for them. This is a protective principle in law that we as a society say we're going to take care of certain people. If they are taken advantage of, if they are harmed, we will act. This, by the way, is where everyone, those who debate this issue, this is where they land. If you go too far in one direction, we have a problem. Yes, clearly we do. But if we don't do anything, we have a bigger problem. If we're not taking care of our brothers and sisters when we should be, our society is not in a good spot. So what we look at is a whole set of ways in which this is being applied now across the board in civil jurisdictions, including the places we live. So who are vulnerable persons is now a very expansive definition. It's including all sorts of people. What we're trying to say, for example, with refugees, is we're trying to say that people who come to our country and are obviously without anything, any protection, they may not even know the language, they don't have any family here, they should not be taken advantage of by people who are seeking to profit from them or people to do bad things to them. We should protect them. So they're being called vulnerable persons. It's become a very broad category. The one that for us is particularly important for understanding Vos Estis Lux Mundi are those who suffer from developmental or cognitive disabilities. The point being, they're not able to understand, they're not able to consent. And for that reason, we have a special responsibility for them. And so in canon law, we now are defining these things as crimes, delicts in canon law. And when a delict is committed, you can bring it to a church court. You can bring it, and I shouldn't say it that clearly. It was that way until recently. Here's a sidelight which might help, especially the students of canon law. Up until quite recently, the hard and fast principle, not really, but the principle was that these things would go to court. They would go to a judicial process. Truth of the matter is, for a long time, we've been using extrajudicial processes for many crimes, including the abuse of minors. The new SST makes that more possible. It makes it quite possible to use an extrajudicial process. So put it this way, you go, you bring it, we have a process for these kind of things. So delicts against the Sixth Commandment. This is going to be important when I tell you what I think vulnerable persons means. We have and have had as a crime, sexual, we call it delict against the Sixth Commandment, which by the way is a very broad topic, on purpose, that's left broad so that many bad things can come in under it. What we look at is the moral canonical tradition from a long time. And so it includes the kind of things that are described more specifically in Vos Estis, but it's broader as well. So if someone commits one of these delicts by force, threats, violence, or by the abuse of office, it can be prosecuted. So please remember this when we talk about our religious sisters or seminarians, vulnerable adults. The answer is certainly, if an abuse was committed against them by force, threats, violence, or abuse of office, use of authority, yes, you can prosecute it. Whether they are vulnerable persons is a question, it's an important question. But is this a bad thing? Should we do something? That's already answered. And now in the new Code of Canon Law, this is in the same canon, Canon 1398 now, in the new Book 6, talks about these crimes. Then the second area, they are committed against an adult. I mentioned before minors. One of the reasons that people have difficulty with this discussion is they think we're leaving behind the abuse of minors, which is so tragic and has been so damaging to the church. I hope that is never the case. I hope that we don't lose our focus, our commitment to caring for minors. One of the reasons that this can help us as you're doing this kind of thing, as you're doing the study that you're doing, is that minors is an objective category in law. There's an age that's defined for a crime. If you fall under that age, you are a minor, and we no longer ask the kind of questions we're going to ask about adults. We don't ask about consent, we don't ask about judgment. If you're a minor and you suffered sexual abuse, it's a crime. That's the problem with what we're talking about with vulnerable adults. We're not going to have that same kind of category that applies to people all the time. In other words, being a vulnerable person all the time. You're going to be found to have been vulnerable in a context, in a particular act. You can be found to have been vulnerable, with the exception of SST. Sacramentorum Sanctitatis Tutela, or better said, the normae de gravioribus delictis, the norms that are attached to the motu proprio. In 2010, defined a new group of people for whom we will provide special protection. In fact, we call them more grave delicts, and if a crime is committed against them, it goes to the Congregation of the Doctrine of the Faith, who are in charge of prosecuting it. So minors and people who habitually have the imperfect use of reason. Now we have to define that, of course. Those people are also in one of these special categories. Now, vos estis comes in a bit later, and we're going to see their definition in just a moment. Talks about those people, but some other people as well. Vulnerable persons. The new Book 6 of the Code of Canon Law simply says those who are equivalent to a minor in law, that is, those who habitually have the imperfect use of reason, are equivalent in law. We call them the same for sexual abuse. And those who are referred to in other laws. Why does it do that? You can ask, sorry, Archbishop Arrieta and I have worked together many years, but you can ask the Archbishop that later on when he's speaking with you. I think the answer is fairly clear. When they wrote the new Book 6, you write these things and they stay in place for a long time. Vos estis lux mundi was given to us ad experimentum for 3 years, which is actually expiring next month. So the Holy Father will decide how to extend vos estis. He can also make some changes to it. So there are a lot of people who are suggesting, for example, that we clarify the use of the term vulnerable adults. But the Holy Father will decide. So Book 6 couldn't refer to something that's going to be revised. It's just obvious. What it did is refer to that the Holy Father can put out special law, and that special law applies to Canon now 1398. Canon 1398 says this is a crime. I just want to say one other thing about canon law. Vulnerability has long been a category in canon law. Vulnerability, and in many civil laws, is what we call an aggravating cause. In other words, if you find someone guilty of having done a certain crime, the penalty becomes stronger because the person was in a position of vulnerability. That's in many civil laws as well. They say, if this happened, then you give 3 more years of a penalty, that kind of a thing. That's long been a case in canon law. You look at the particular gravity of the crime when you're applying the penalty. All I want to say in all of this is this is not foreign to canon law. Definitions, phrases, and all the rest. But when you're actually looking at it, you look at what it is that's been done, understand what's been done, and then realize where we're going with it. So we're almost done with foundations here. If you look at CIC is the Code of Canon Law, CCEO is the code for the Eastern churches. They simply speak of offenses against chastity, period, the end. So all of this, put it this way, is developing. SST, vos estis lux mundi, as you know. I call it vos estis. I don't find velm to be all that felicitous. But vos estis speaks about, in 2 ways, these crimes. Those 2 ways are sexual abuse and crimes of pornography. Crimes of pornography, very interesting. Remember when I said minor has a definition in law, and I didn't say 18 years old? Up until very recently, for crimes of pornography, a minor was 14 years old. So think about it. Somebody's downloading, well, defining all of this. Someone is actually making, and someone is then consuming, as we say, pornography. How do you know how old that person is? So it's a crime. But how in the how do you know how old the person on the screen is? That's the defense that you get if you're a judge. I didn't know how old the person was. Well, we've raised it. The Congregation of Doctrine of the Faith and vos estis have raised this age now to 18. If the person is under 18, it's a crime. As you can see, these things are not easy. When they're brought to court, these things are not easy. So we use the phrase delix against the 6th commandment. Those are the canons. By force, threats, or abuse of authority. You see, it was in the 83 code. That's a mistake, I'm sorry. Actually, no, that's correct. It's in 1395. And interestingly, the word grooming is used for the first time in canon law. You can certainly ask the Archbishop about that. It's interesting, number one, that it's being used and how we prosecute it. It's also interesting that it's only used right now in the context of pornography? Why is it not used in the context of sexual abuse? There's a question for, this is how things develop. This is how laws grow, and this is how we grow. And for the first time, negligence is defined in vos estis in the same context. If there's abuse and we don't do something about it, it also can be prosecuted. Civil laws is a whole nother discussion, which I'll give you some civil laws at the end so that you can see. But put it this way, there's much going on in terms of the use of this term, the understanding of this term, to what it applies all over the world. I'm just giving you some examples here, which we're going to refer to later on. So context and relationship, a little more quickly now. Taking everything we have and using all of these fonts, the first thing we have to ask is the person who has been harmed. Is this person a vulnerable adult? Asking whether the person is a minor, as we said, is an objective category. You are or you aren't. You're under 18 years old or you're not. Elderly, as you can see, is a little more difficult. We have that term, particularly in civil law. There's protection for elderly persons, but what age does that begin at? Again, I'm not going to address that, but there are subjective aspects. The reason I include that is because you see also with things like disabled. Yes, people are disabled and you can get a thing for your car so that you can park in the special spots, but are you disabled in every situation? And what does it mean, cognitive disabilities, when you can't understand what somebody's doing and therefore can't consent? It becomes even more difficult to apply these. There aren't fixed categories. And I think that helps when we talk about vulnerable persons. We're not looking for a fixed category. That's not our goal. What we're looking for is applying the law in particular situations. So is a religious sister a vulnerable person? A question that is being asked in many, many places. As we've heard in our presentations in this conference, it depends on what you mean by vulnerable. It's a wonderful word. Vulnerable for us is a very important term in terms of our relationship with God. And we speak about our Lord becoming vulnerable to us. The word actually in its root is speaking about the vulnerability that he experienced on the cross, and that we would be vulnerable in our relationship with the Lord is a good thing. It gets a little more complex when we talk about human relationships. When we talk about religious sisters, should a sister be vulnerable with her sisters in community? We use that term often as well. We use it in a good way, that if we're really going to have deep relationships, we have to be willing to place ourselves in a situation where we could be hurt. But obviously it's getting a bit more complex here. Now, when you start talking about her superior, it's getting even more complex. Should a sister be vulnerable before her religious superior? Vos estis, for the first time, has defined crimes by religious superiors who are not clerics. In other words, up until now, we just talked about clerics. And there was a revision, which probably most people have missed, after the new book 6 came out and started talking about all religious women, men, brothers, religious sisters as committing crimes. Unfortunately, there was another canon that referred to religious, Canon 695, which referred, it said, see Canon 1395. Well, we changed Canon 1395, so the Holy Father had to go back and revise that one as well. So now, really for the first time, we can prosecute as a crime religious sisters, religious superiors, for these crimes against their sisters. And we're speaking about vulnerability in that context. We're speaking about power differentials, we're speaking about authority, and if that authority is misused, how is it that a person can seek relief? The great question really comes down to, for us though, in the law, is a religious sister a vulnerable person? Let me expand the question to, is a seminarian and a religious person vulnerable? Okay, here's the definition from Vos Estis, and I'll tell you what I think. With all of that as the background, the definition says that any person, so now we're talking about anyone, we're not just talking about specific groups of people. Anyone who's in a state of infirmity, physical or mental deficiency, or deprivation of personal liberty. Those people who are not able, jump to the end, those people who cannot understand, and are unable to resist. They're unable to give their consent. I think the key here is the middle part of this definition, and it's what's often missed. The middle part says, which in fact, even occasionally. In other words, it connects those two parts. In other words, we're not just talking about people in the third part there. We're not just talking about anybody who can't understand or resist. We're talking about, if you will, disabled people. People who suffer from a particular disability and for that reason. So take a seminarian. If a seminarian is a position where he's infirmed, physically or mentally deficient, or deprived of personal liberty, I'd have lots of questions. Why is he a seminarian? If a seminarian comes and says, my superior sexually abused me, it gets prosecuted under another canon, but it gets prosecuted. In other words, we don't make the seminarian a vulnerable person and then prosecute it. We say we have a canon that if you do this by force, threats, violence, or abuse of authority, it's a crime. The same really is with religious sisters. The only difference is we do have religious sisters who are older, religious sisters who do fall onto this because of sickness or ill health or all sorts of other things. It can happen. But normally speaking, if a religious sister has been harmed by the priest, by a superior, by anybody, we call it a vulnerable person if it fits this definition. We call it another kind of crime if it fits another definition. That's my interpretation. What I have for our discussion later on is the same kind of response from an archdiocese, which I won't name, but I thought good and worth us discussing, because you may disagree. But when asked, the representative of this diocese said, no, the term vulnerable adult doesn't include them. What really the term vulnerable adult in church law is getting at is people with developmental disabilities or cognitive disabilities. However, our policies, the way we do things, should account for non-consensual sexual conduct, as well as any conduct that's a violation of civil law, which is interesting because civil laws are very different. So I will present that to us a bit later on. What I'd like to just give you is a couple of things that may help in terms of why and how this is developing in civil law. So as we look at, first of all, do we agree that this is what church law says? Then as we look at how is it that the church can take what we have, these two different canons, that says we should give protection to these people in these situations, how do we apply them? And this is where I think we can learn quite a bit from those who are working in this field and the presentations that you've been hearing and all of the different fields that we collaborate with. We can learn an awful lot about how these things are being handled. And then we can ask ourselves, what should we be doing as a church? Who is it that deserves special protection? When someone comes to us and says, I've been harmed, what do we do? I will say that we should listen to people carefully who have difficulties with what I just said. We have to hear and understand and respond. This is part of being a listening church, because they're not wrong when they say you could extend this way too far. Everybody who has a dispute is going to come to us and seek a judicial decision. God help us. So bringing clarity and discussing and working together as we're doing here is very, very important. What I'd like to do is just share with you briefly, the next 4 slides, I think, are a paper from a paper that will be published soon by Justice Neville Owen, he's a retired Supreme Court Justice from Western Australia. He's a member of the Pontifical Commission for the Protection of Minors and Vulnerable Persons. As part of the commission, Neville developed a paper to help the commission understand, as it advises Pope Francis in these matters. And what he's trying to say is that we can learn, he comes from the common law tradition, obviously, we can learn how judges like himself receive a case and apply the law to that case. And in so doing, look at how many judges have applied the law and the distinctions that they're making and the ways in which they are developing what in common law are doctrines. They are principles that become binding then for those who follow. In other words, when decisions are made in this tradition, these things move forward. They're debated at great length, but what he's saying is that the law does seek to protect people under disability or disadvantage. And so we should look at how it is that they answer these questions. And in particular, we should look at, as we said before, the relationship. Don't just look at the person who was harmed and try to decide whether they are developmentally or cognitively disabled. Look at their position vis-a-vis the person who has harmed them, and look at how that act, the action which we call a crime, harms this person, and whether or not the person who was harmed was capable of making a response. So these two ways of answering the who are ways of trying to provide, as it says there, standards that are fair, just, and reasonable. This is why it's difficult. It's difficult being a judge. It's difficult identifying these principles. What do we as a society think is fair, just, and reasonable? What do we think is not, which we're going to call unconscionable in a moment? And does it fit this case that is here? So this all developed from what we call equity with a capital E, actually. What is it that we understand these tests to be? Meaning, when you ask, is this a vulnerable person in this case, you have tests, you ask questions. The kind of question you ask about the person who harmed somebody is you ask, is that person, what that person did, in our understanding of what's conscionable, guilty of a crime? Or we ask, is this conduct seen by us as so abhorrent, taking advantage of someone's disability, their vulnerability? Is it done in such a way that we find this something we should respond to? So notice there's three things here. There's the relationship. The relationship we call a special disadvantage. One person in this relationship is at a disadvantage. Second is the act itself. The person who acted took advantage of it knowingly. They exploited the person. Think of the financial example we used before. This salesman, this isn't being translated, right? Schmoozed. How do you say schmoozed in French? This salesman came in and took advantage of this elderly woman by convincing her that something was a good thing when he knew it wasn't, and he knew she wasn't able to understand what he was saying, sold her something, she lost all her money. This is unconscionable. And therefore, it's unreasonable, it's oppressive, and therefore the doctrine of equity says we're going to do something. So those are the person who did it, the act itself. Now you look at the person who signed the piece of paper, the elderly woman, and you ask yourself, was she a person who, under our doctrines of fairness and of justice, was acting in a way that deserves this response? In other words, a disabled person is easy, elderly people in certain situations, but now we get into more difficult situations. I have to be careful giving you examples because they come from my own experience, but unfortunately I've had a lot of experience, so you will not be able to identify this person. A religious sister come to me. She came to a certain country. She was brought there by a priest from a religious community. This happens all the time. And she was brought to the country and she was given a scholarship at a university, and some advantages were given to her family back in her home country. Everything was going fine. She learned very quickly that she was expected to do certain things in order to keep that going, and then was threatened that if she did not only would she be thrown out of the university, she would lose her visa, and consequences to her family back home would be following. Is that person in that situation able to exercise judgment and to consent to the act? That's what we're talking about. So this gets into the second part, which we call undue influence. This more has to do with the person who is harmed and their actions. Did they make this decision based on undue influence? So that's how you take the idea of vulnerable persons and apply it to a situation. What you have to look for, what we're looking for is, these are words from Western Australia. So psychological ascendancy, our experts here can give us other words. But the idea is that one person exercised influence over another that we recognize as something that is wrong, and therefore we can take action. You see, it's not that complex, honestly. There is much here, I think, that we can profit from. And then what we look at this is in a church context. How is it that we wish to respond? And a lot of this is us coming together. A lot of this is us as a community deciding that these are the kind of things that are happening amongst us, and we want to act. And honestly, that's what's happened, thanks be to God, with the abuse of minors. I began this work 20 years ago, and we decided as a church we were going to act. And the safeguarding procedures that have been put in place around the world to respond to this evil have been remarkably effective. Never fully effective, and every single case is tragic. But we did. We decided together, and we're doing it. Thanks be to God. Question is, in our civil societies now, these same things are happening. What is it that we think we should be doing, and how should we be going about it? And then are we going to put the resources into training people to actually do this that it's going to take? So Ottawa, for example, uses the phrase vulnerable sector. And in the laws of Ottawa, there is an idea that there are people who are at greater risk, and it has to do with age, disability, or other circumstances. Notice how broad that decision, phrasing is. If a case is brought to you and you're the judge, and somebody says, because of other circumstances, I want you to do something. These things develop over time. Also here in Canada, in Quebec, there's a law that will come into effect in November of this year. And it talks about strengthening procedures that have been there, looking at the ability for people to exercise their rights and their autonomy. And it's called the protection of persons. Obviously very large. You can find these things quite easily, by the way. You can find these very easily on the internet, and you can see the great variety of things. The City of Toronto has a working group on vulnerable individuals, and they define vulnerability as the result of an interaction between the challenges a person faces and the resources they can access responding to these challenges. So in other words, if a person doesn't have sufficient resources personally to respond, they can be in a position of vulnerability. This one is interesting. This is the only one from the United States I have here, but the one in California, I think, gives you an idea of the kind of tests that are used in civil law in order to decide, has this person been taken advantage of in the situation? They look at, as we've been saying, vulnerability of the victim, the influencer's authority over them, the actions or the tactics that are used, and the equity of the result. Those are the tests that they use to decide the particular case. All I'd like to say at the end is, if a case comes forward, please be clear. At this point, we have decided as a church, we will respond. You just want to get it to the right place. And if you don't know the right place, please ask. The Congregation for the Doctrine of the Faith has put out a document they call the Vadimecum, which means to walk with you. And the Vadimecum says, I think 3 or 4 times, I looked it up, please call. If you have a group, it's calling it bishops, but it says, if you don't know what to do, please call, we'll help. Now they're believe me, they are swamped. The new secretary was just recently named for the discipline section, and the congregation called it a tsunami. They got lots of cases, but they want to help. So if it is a civil crime, we should go to civil authorities. If it's a civil crime, if it's defined as a vulnerable person, they have the resources, the civil government. But believe me, this is difficult. Please think about families and how difficult it is, and you can then extrapolate then further along. If an uncle is abusing a nephew, do you want to go to the civil authorities? So the difficulty of that plays into all of this, but it's a civil crime. They should deal with it. Is it in SST? Is this person someone who was harmed by a cleric? SST only deals with clerics. In other words, if it's not a cleric, it goes someplace else. It's still a crime. It just goes to somebody else. If it's a cleric, and if the person habitually has the imperfect use of reason, it goes to the CDF. If you don't know, just ask them and they will tell you. If not, it goes to the local ordinary. It goes to the person responsible in the diocese, interestingly in both SSTs, either the diocese where the person belongs or where it happened. You can go to either one. It's the first time it's been defined that in that way. And is this perhaps something that is dealt with not in a judicial process, but through a disciplinary process? And most dioceses now have what they call review boards and other types of places that go and cases are brought to them, not in a judicial context, but the bishop brings misconduct and brings it before the review board, and they advise him on how to go forward with all of this. The Pontifical Commission is very clear about their desire to help move this discussion along, and has been. And so what they're seeking to do, and this is why the Holy Father called the commission together, is to collaborate with people like yourselves in moving this discussion forward. I do think that when we talk about justice and healing, we need to have our perspective properly placed, always listening to the victim, always giving welcome, always making them understand part of the effect of sexual abuse is they feel cut off. They feel separated. It's working with them and then working with all those affected, because those affected is a very large. Sorry, we started late and I went a little bit long. But the idea that I'd like us, as we are able to do, is to simply talk about this as you're clarifying what it is that the meaning is, to talk about whether you agree that no, the law doesn't currently say that, but we should handle these things in other ways. Thank you.